All right. If there's something you don't understand, let me know. All right. And I understand that sometimes when people have been to law school, like for example, I haven't really worked on cars. So there's a little stuff I can tell you about being a mechanic, but I really don't know the ins and out of every vehicle. You understand? All right. So number 3, and we actually have to pay state bar dues every year. And when that comes around every year, everybody's like, oh my gosh, state bar dues.
Do you know?
Yes. So the state bar is not participating in this trial. How's stock investment going?
I don't like to get political.
When people bring out guns, guess what? If you end up firing it and it ends up hitting someone, there's no turning back from that. Court is finding you guilty. The court is sentencing you to 16 years in the prison, give you credit for any time served. All right, and are you Mr. Beltran?
Yes, Your Honor.
All right, in defense, you said you've adopted his motions?
Yes, Your Honor.
All right, so the first motion is a motion for a special appearance. Under the authority of Texas Rules of Civil Procedure 120A for the divine purpose of objecting to the de facto district court's abstract subject matter jurisdiction,
Hello.
non-ex parte third party waivers allowed. So let's address that motion.
Yes, Your Honor. My client's position is that that there is a defect in the abstract subject matter jurisdiction, that he has been brought into this improperly because the state would be the plaintiff, and they brought him in and are litigating that, and that there's a jurisdictional issue, that the court does not have in persona or subject matter jurisdiction.
All right, is there a response, Sate?
Judge, as a criminal district court, the court does have jurisdiction to preside over any matters. The defendant has been charged by indictment with the offense of aggravated robbery, and that occurred in Dare County, Texas, and so the court retains jurisdiction over those proceedings.
All right, so Mr. Beltran, anytime that there is a criminal case that's deemed by the penal code to be a felony, then that comes to a felony criminal court. All right. And then the next question becomes whether or not a grand jury has been given evidence. You've been indicted, so they've been presented with information, right? And if it's alleged that the incident occurred in Bexar County and it's a felony, then I would have jurisdiction over the case. So if for some reason this was a case that is alleged to have happened in another county, let's say it's Hayes County or Harris County, then I wouldn't have any jurisdiction over it. Do you understand? All right. So with this case, I'm not taking any of it to be true because I have to wait till evidence is presented to me. But looking on the face of the indictment, and I'm sure your attorney will tell you, an indictment is not evidence of guilt. It's just the means whereby a person is held over for trial, right? And so when a grand jury indicts a case, they're just saying there's enough evidence to hold you over for trial. They're not saying it's evidence beyond a reasonable doubt. And when information is taken to the grand jury or evidence, police reports or whatever it may be, and it has to be allegations that it happened in Bexar County, and it has to be allegations that it's a felony. Now, if this were not alleged to be a felony, then it wouldn't be in this court. Even though it would be a criminal case, it would be sent to a misdemeanor court maybe, or perhaps even a municipal court. But because aggravated robbery, according to the penal code, is a felony, it's supposed to be in a felony court. And then if they're saying it happened in Bexar County, then it would come to a felony district court, state district court that's in Bexar County. And that's where we are. You understand? Is there anything you not understand about my ruling on that? All right, thank you. And then we have, yes.
Excuse me, did the court take judicial notice of the indictment in this case?
Yes.
Make its ruling, okay.
Yes.
The
next we have new discovery of ex parte corpus trust fraud upon the court that conceals the facts that the charging instrument lacks subject matter controversy no injury in fact exists.
Your Honor, I believe what my client meant by that is just kind of coupled with the first paragraph, that the court his position was the court didn't have jurisdiction. The court just ruled that they did. That then the indictment would not be valid in this case. So I think that's what the client is trying to say.
All right.
Did I get that right?
Yes.
Okay.
All right. So State, you want to address the issue and what and if I'm interpreting this incorrectly, let me know, okay? So you are saying that the offense, that there is no subject matter jurisdiction because there's no injury by any party?
Yeah.
All right. So if you can address that.
Your Honor, this case was presented to a grand jury that was duly impaneled. They indicted the case. They returned a true bill of indictment. The indictment does comply with the penal code and the code of criminal procedure, which governs in this case. And it does allege the requisite elements for the aggravated robbery. And so it's a threat by using a deadly weapon. And so that is the harm. The crime was committed against the peace and dignity of the state, and there is an alleged complainant.
All right. So Mr. Beltran, do you understand with the charge of an aggravated robbery case, sometimes it's alleged that a person maybe pulled a knife on somebody and said, give me your money, right? I don't know any of the facts about your case. The only thing I can do is look at the indictment, right? And then sometimes it's alleged that somebody pointed a gun at somebody and said, give me your money. The way indictments work is if it is a crime in the penal code, and there's a list in the penal code of all the crimes, and aggravated robbery is one of those crimes that's listed in the penal code, and it sets out what the elements are of that. Now, you're saying that there was no injury in fact exists. The only thing the state has to do is prove the elements that are in the indictment, and the indictment has to show the offense that is in the penal code. You understand? So do you understand? You gonna have any questions about the court's ruling?
Yeah.
All right. If there's something you don't understand, let me know. All right. And I understand that sometimes when people have been to law school, like for example, I haven't really worked on cars. So there's a little stuff I can tell you about being a mechanic, but I really don't know the ins and out of every vehicle. You understand? All right. So number 3, defendant is erroneously charged with an abstract offense. See, I don't know, I can't read that word. Something taxation. District court is criminally attempting to receive an unauthorized, colorable, no fault immunity third party benefit in violation of the 7th Amendment. All right, do you want to address that, counsel?
Yes, I believe my client, I think it just goes back to being a third party brought in here without abstract subject matter jurisdiction, and the fact that he was brought into this case. I believe that's it. Is that it? Okay.
All right, State, do you want to respond?
Judge, regarding, I guess, the 7th Amendment applying in the case, or, okay.
Yes.
That is for civil suits. We are in a criminal court, and so I would argue that that does not apply here.
All right, so the 7th Amendment applies to jury trials that you're entitled to, and that is in federal civil cases. Here, you do have a right to a jury trial if you want a jury trial, and if you want a jury trial, I'm going to make sure that you have a jury trial, okay? And then the other issue, let me see. I don't understand when you say, explain it to me. You're saying district court is criminally attempting to receive an unauthorized, colorable, no fault immunity? What do you mean by that? Because what I can tell you is I don't receive anything related to these cases. Of course, as a judge, I'm paid a salary for the work that I do, but I don't receive any funding or extra funding based upon how I resolve cases. Do you understand?
Yes, ma'am.
Do you have any question about that?
No, ma'am.
All right. So then the other one is dishonest services that rises to constitutional tort and national security concerns, communist activity detected in violation of Title 50 U.S.C.S. 841. This court now under federal questioning under Title 28 U.S.C. 1331, light of new evidence investigation hypothetical claims. All right, defense.
I'm not sure what my client means by that. I'm going to ask him to explain it.
All right, if you could explain that to me, Mr. Beltran.
I guess what I'm trying to say there, Your Honor, is how the state of Texas is plaintiff, and they're the ones that are pursuing and to prosecute me,
Mm-hmm.
which is they're one of a third party,
Okay.
and I'm not. I don't third party. I'm not sure how that works. I know
Okay.
how civil suits, and I know it's criminal law, but I know that. I mean, how can I cross-examine the state of Texas? How can I?
So let me explain something to you. Whenever you see cases on the criminal side, it's not individuals versus individual. Usually when you're on the civil side, if it's a marriage, it's individual. If it's civil. All right, here, the reason why it's the state of Texas is because in criminal court, it's not you versus the complainant. Whoever the complainant is in this case that you're accused of committing aggravated robbery against, yes, it's alleged to have happened that you committed an aggravated robbery against them. But the state of Texas, the way we were taught in law school, the state of Texas takes offense, right? Because whenever an offense is committed against a citizen, it's the offense against the citizen, but it's also the offense against the state of Texas. So in cases such as these, the state necessarily is not the complainant. They're just bringing the suit or the case because the state of Texas is offended that an offense is alleged to have been committed within the state of Texas, within the county of Bear. So that's why the state of Texas is listed and not the complainant. Do you understand?
Yes, I understand that. And so, how do I cross-examine the state of Texas?
The state of Texas, you don't cross-examine them. The persons you would cross-examine would be any witnesses the state of Texas would call to try to prove that you've committed an offense against the sensibilities of the state of Texas. So, for example, for an aggravated robbery, they'll need to call somebody to prove that it happened in Bexar County. They'll need to call somebody to prove that it happened on or about whatever date it is. If there's a weapon used, they'll need to call somebody to prove that a weapon was used. And they may need to call a complainant to say, hey, I'm the person in your indictment. You
I
understand?
understand, Your Honor.
All right. Do you have any questions or any confusion? All right.
May I ask my client a question before you go on to next? Are there any other things in here? Because some of it repeats itself. Were those the main points?
Other than anything.
Or is there anything else in your motion that are different that we need to bring to the court's attention that would be different?
All right. So Then with regards to that motion that's combined from page 1 to page 6, then the ex parte relief requested will be denied. Now, by denying that, that doesn't mean that if there's a jury trial, your attorney still will not have the opportunity to question whatever witnesses the state calls, okay?
Understood.
So that will be denied.
There is it appears to me that there was like 3 separate documents stapled together, because that's the way it was received.
Yes.
There is the next one, which is exhausting administrative relief.
Mhm.
My client is not wanting to have that heard right. It deals with ineffective assistance of counsel. Right, Mr. Beltran, that's not to be heard right now? Okay.
And let me explain something to you. I understand that's not to be heard right now, but what I can tell you is attorneys who are appointed to represent people, those are attorneys who are on the wheel for appointments, right? And if this is a first-degree felony, just from the face of what I'm looking at, and if Ms. Gay wasn't qualified according to the qualifications to be on the wheel for first-degree felonies, she would not have been appointed to represent you. Do you understand?
Understood.
And Ms. Gay, are you on the first-degree will?
Yes, I am.
All right.
So the next document is entitled Court Constitutional Notice,
Mhm.
and that addresses antitrust violations, fraud upon the court, actions of the state bar.
All right. Do you want to take these one at a time, counsel?
I guess so, Your Honor.
All right. The first is new discovery of antitrust violation lies brought upon the court. Elected state bar officials, seditious organization, are conspiring to fraudulently conceal the ultimate fact, Sixth Amendment misconduct, that the State Bar of Texas lacks capacity to prosecute a natural person. It is an improper plaintiff. All right. So with that, I can tell you the State Bar of Texas is not prosecuting you. The State Bar of Texas is more of an affiliation that attorneys are required to belong to. And we actually have to pay state bar dues every year. And when that comes around every year, everybody's like, oh my gosh, state bar dues.
Student.
Yes. So the state bar is not participating in this trial. Now, I can tell you as an attorney, your attorney as an attorney, and the state as an attorney, anyone who's licensed in Texas, they're required to be a member of the State Bar of Texas, and they have to pay dues to the State Bar of Texas. I think it's $265. It may have gone up. All right. So they're not going to be trying you.
Yes, sir.
All right. The next one is State Bar's virtually gathered evidence, video, police reports, third party. Again, what I can tell you about that is the State Bar hasn't gathered any evidence. State.
I think I just put, I'm sorry, Your Honor.
Yes.
I think I just put that as.
All right. So do you want that heard or no? All right. And then the next one is, so to permanently prevent a false state bar, anything with regards to the state bar, do you still want that heard or no? It says objects to Texas State Bar ex parte matter waivers and fictional double jeopardy defective jurisdiction. Do you want that heard?
Yes.
All right. Defense?
My client believes that, again, that the court does not have jurisdiction, that he is concerned about his waiver of his constitutional rights. Some of this deals with what happens at trial, like hearsay evidence being admissible, being admitted wrongfully, and that he still believes he's a third party, and that there's abstract jurisdiction, and that the court doesn't have the power, I'm guessing, to rule on evidentiary issues such as 901, and that, in other words, probable cause is third-party fabricated, then secretly planted and dressed up to appear that it has merit, but it does not. So he is talking about one jurisdiction and also trying to state his right to object to evidence.
All right, State, do you want to address that?
Regarding this collection of evidence, I'm not sure.
Oh, no. So, let's address double jeopardy. Double jeopardy, defective jurisdiction. So double jeopardy, if you have not been previously tried for this same offense before, that's what double jeopardy is. Basically, in a nutshell. There are certain exceptions to that. But when you mention double jeopardy is you've been tried for something before and you were found not guilty, right? And now the state is trying to try you for the same thing, even though you were previously found not guilty of it. Or either you had something that was dismissed with prejudice and they're coming back and trying to try you for that same offense. Do you understand?
Yes, ma'am.
State, has he been tried before for this same offense?
No, Judge, there has been no actions on the indictment or the indictments that are pending against him. And as far as I know, he's not been charged by any other jurisdiction regarding this.
And there has never been anything pre-indictment that was dismissed with prejudice with regards to these cases?
No, Judge.
All right. Does that address that issue for you?
Yes, ma'am.
All right. Then the next one, deceitful corporate veil and trumped up judiciary immunity is fatally pierced. I do not forfeit my privileges and immunities under the 4th and 14th Amendment. What I can tell you is during a jury trial, when the state calls their witnesses, your attorney will have a chance to cross-examine those witnesses. The rules of evidence do apply. If she finds that there is some question that is objectionable and should not be answered, then she will stand up, make an objection. Normally, the objections may be hearsay, entering the province of the jury, assuming facts not in evidence. It could be relevancy. It could be 404B. It could be any of a number of objections that she can make. Once she makes those objections, I will make a ruling, and my ruling will decide whether or not the witness can answer that question and whether or not the jury can consider it. Do you understand?
Yes, ma'am.
All right. Does that address that issue?
Yes, ma'am.
I think the other issues deal on the second page, deal with State Bar, and I think the courts address that.
Okay.
The other one is the gross advertising negligence of the DA's office,
Okay.
and defendant being sued,
Oh, who's being sued?
the defendant.
All right. So, sir, there are different type of suits. There are civil suits. So technically somebody can be sued civilly for something. Sometimes with criminal cases, people will say, oh, it's a suit. Technically it is sort of a suit, but it's again, the state of Texas versus whoever the defendant is. You understand?
Yes, ma'am.
All right. Do you have any questions about anything else? Okay. And then the next page, page 6, it has postscript. Is there something in there that needs to be addressed? I think it says here, it has to do with cross-examination. And then he say the plaintiff is in harmless artificial corporation. Are you talking about yourself or the state of Texas? Okay. All right. So whether or not it's a fishing expedition or corporate entrapment or a Ponzi scheme, that'll be something that will be decided during the jury trial. Okay.
Yes, ma'am.
All right. All right. Is there any other motion that needs to be heard?
Anything else? Any other jurisdictional arguments that were raised? that we have not talked about and the judge has already ruled? Anything other than,
No.
All right, is there anything that you don't understand about the jury trial process?
Mm.
All right, so I will still give you a choice. If you want a jury trial, you can have a jury trial. If you want a bench trial, if the state agrees to the bench trial, then we can have a bench trial. As I've told you before, if the state presents evidence that proves you guilty beyond a reasonable doubt, that means each and every element, I'll find you guilty. If they don't, I'm going to find you not guilty. You understand?
Yes,
All right, so if you still want a jury trial, Norma, is he already scheduled for jury trial?
Not scheduled for yesterday, Judge.
All right, so, counsel, you're still requesting a jury trial? All right, Norma, if you can put them on the jury trial, please, and Ms. Galloway, if you confer
Yes.
with the defense on a jury trial date, so they're gonna get a jury trial date, okay?
Thank you, Your Honor.
Oh, you're welcome. And who's the attorney on Edward Rodriguez?
Here, Judge.
Okay. Rebecca Davis? Hello.
Hi.
All right, so have you conferred with the state?
Yes, I have, and they are not opposed to the occupational license. She is currently complying with her conditions, which is to have the interlock device. So she has that on her vehicle.
Okay, we'll need to go on the record.
Okay.
All right. Could I have someone from the state? The court is calling 2025 CR 003154, which is the trial court cause number, and 2025 CI 11673, which is the civil request for the occupational driver's license. Could I have parties announced for the record?
Jason Garahan for the state, Your Honor.
Arlene Kay from Ms. Davis.
And are you Ms. Davis? All right, so there's a request for an occupational license, and you may proceed.
Your Honor, my client filed this pro se, and I found out that I was appointed to assist her today. So I have gone over the document. We talked about it. She does have the interlock device on her vehicle. This is an essential need. She is starting a job on the 26th of this month. She is living in the SOBA facility, rehabilitation facility.
Mhm.
They do allow vehicles. And, you know, besides the interlock device, she is tested for drugs and alcohol routinely while she is there. She wants to start her job. Also, she will need to drive to get to not only in the future doctor's appointments, but also appointments related to her probation. And then we have the household going to HEB, getting gas, things like that, that she's asking to go to. I believe that the statute allows to drive up to 12 hours a day. I think she put from 6 a.m. to 6 p.m. now.
Well, what I can tell you all, and let's go off the record. Okay, this is what I need that's not in this document. I don't have any proof that she has insurance. So if we can have that in the document.
She has her SR-22 with her.
So if you want to make copies of that,
Okay.
or is that your copy?
Yeah.
I will have my interlock, my driver's record,
That's what all needs to be here. So,
at least certified myself,
Okay.
and my treatment, presence of treatment letter and my actual life.
all right, state, have you had a chance to review those?
I believe my co-counsel has.
Okay.
We have no objection, Your Honor.
All right, so that's what I would need. And also, there is a section in here that they would like you to check off the times that she would need to be driving. So if y'all could go through that document or make a copy of the document, because technically it's filed. And if you all can make a copy of the document and put in what you need to put in.
Okay. And Your Honor, do you want these attached to
Yes.
it? So I can get it and just put first amended
Yes.
and attach proof, and then
So I'll need the proof of ignition interlock,
Mhm.
the proof of insurance, and she needs to put in what time she's asking to be allowed to drive.
I'll talk to her about that, because 6 to 6 sometimes jobs
Okay.
may be a little difficult.
All right. So if, once you all do that, you can come back.
Okay, great.
Thank you. Thank you.
Your Honor,
Yes.
she did not include it in the order.
She did not do what?
Include an order, because the form didn't have an order, and she didn't know what an order is.
Okay.
So whatever we do today, I'm gonna have to go back to my office to
Well,
type
I
up
tell
the
you what,
order.
if you'll type it up, but I am going to be gone next week at a CLE that I have to speak at, but I'll be here tomorrow.
Yeah, I can type it up and bring it tomorrow.
Okay.
Okay.
All right. Just bring it and I'll take care of it. Thank you. And continue with the good work. Okay.
Yes, ma'am. Thank
All right. Who's here on Omar Herrera?
Right here, Tim.
And then after Omar Herrera, oh, there are two. And Vashawn, this is an application. All right, the court is calling 2025 CR 003736 and 2025 CR. Oh, afternoon. How are you doing today?
Nervous, but here we are.
Hey. Who is here on Matthew Rendon? Hello.
Judge, afternoon.
Oh, afternoon. How are you doing today?
Nervous, but here we are.
Hey. All right. The court is calling 2024 CR 2339D State versus Matthew Rendon. Can I have parties announced?
Megan Galloway for the state.
Victoria Cruz on behalf of Raymond Martinez for the defense.
All right. And are you Mr. Matthew Rendon?
Yes, ma'am.
All right. Do you have any objections to this attorney standing in?
No, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor. Defense is satisfied.
All right. Court will find that the state is in compliance with discovery. Mr. Rendon, did you review the document entitled Deferred Adjudication or Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we move to proceed on count 1 and waive and abandon count 2.
No objection from defense.
All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
All right. You're charged with aggravated assault with a deadly weapon. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you understand?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Rendon, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, there's a $2,000 fine. If the court finds that a deadly weapon was used, there's going to be an affirmative finding of deadly weapon. The state recommends deferred adjudication, and there's restitution, if any, to Oscar Del Fiero. Fiero?
Yes, Your Honor.
All right. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea?
Yes, Your Honor.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 5 years. There be a TAP evaluation, 200 hours of community service restitution, no contact with Oscar Del Fiero, Anthony Cochran, Richard Campos, and the hostility management course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead to count one? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offer states one and attached.
No objection from defense?
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, please.
Anything you wish to say on behalf of your client?
Not at this time, Your Honor.
All right. Are you currently employed?
Yes.
What do you do?
My family has businesses. I do stocks on the side.
You say
Mostly-
stocks?
Yeah, like stock market. I'm an investor.
Oh, okay.
I do a lot of entrepreneurship.
Okay.
That category of work.
How's stock investment going?
I don't like to get political.
No, no,
It
no.
affects it, but it's good. I make good percentages yearly. It's good money.
No, I asked that. I have friends who do the stock market and they're always coming to me and I'm like, don't get married to the stock. Don't marry it.
It's a lot of this.
Oh, it is. All right. Do you have any children?
Yes, ma'am.
And what are their ages?
I have a 4-year-old son and a 3-year-old daughter.
Okay. All right, this is what the court will do. The court is going to sentence you to 5 years deferred adjudication. There's an affirmative finding of deadly weapon. There's to be regular reporting by Zoom or in person, regular random UAs, $2,000 fine probated. There's to be restitution, if any, to Oscar Del Fiero. State, when do y'all want the restitution hearing set? All right, can I have 30 days for a restitution setting, please?
What about this one? What about this one?
Sure.
Also from the 7th century, Fuller tribe, I believe.
I think it was taken from British sources, but it's from Wakanda, and it's made out of vibranium.
And it may be a restitution amount that they agree on, but I've learned that when you don't set a restitution hearing, it just floats out there.
Yes.
And so I want you to be able to know what the amount is.
Judge, if you give me just a second, I'm looking up another court paper for Megan.
Okay.
Please.
Oh, no problem. All right, while they're doing that, I'll continue. So there's going to be 200 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service will be deemed satisfied. People always wonder, why do you order parenting classes? And the reason why I do it is because when people are making these choices, they need to think about their children as well. What would happen if I go to prison? And they're not really thinking about that. They're in the heat of the moment. And let me do this. There's going to be parenting classes, 100 hours deducted for the parenting classes. And then I'm going to order the hostility management course that was recommended. And then once you complete that, the remaining 100 hours will be deemed satisfied.
Thank you, Your Honor.
There's to be no contact with Oscar Del Furio, Anthony Cochran, and Richard Campos. And there is to be proof of employment within 30 days, no employment as a home health care provider or with minors. Probation, is there anything? Thank you. Field visits 1 time per month for 5 months. Anything else, probation? Is there anything else you need from the court in order to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. Do we have a date?
July 24th.
All right, so what's going to happen on July 24th? We'll be back here, and that's for us to get an amount of restitution that is owed, and your attorney will have a chance to either object to that amount or agree to that amount. Do you understand?
Yes.
So let me explain something to you. When people bring out guns, guess what? If you end up firing it and it ends up hitting someone, there's no turning back from that. You understand? So you're going to have to start thinking and putting your children at the forefront of your thoughts in everything you do, because everything that you do ultimately ends up impacting them. If you go to jail, even if you're in jail for 30 days, getting a bond, it's where's daddy. If you end up going to prison, it's where's daddy. And then that snowballs other thing, because sometimes you have women who will wait for you after you get out of prison. Sometimes they don't. And you know what that means? That means that somebody else that you don't know is raising your child. All right. If you need anything, let probation know. If you feel they're not addressing it, you can always come back to the court. Okay.
Thank
All right. Good luck to you.
May we be excused, Your Honor?
Yes.
Thank you.
Let me put this in the system. Everything must go in Odyssey now, and Odyssey is slower than my typing. Okay.
Teacher always tells you to pay within the lines. So you literally does not care at all. He's coloring all over the place. What? Is this a new style I never learned? Bro, what? I feel like he's bringing all the...
And 3 cases?
Yes, Your Honor.
Okay. Court is calling 2025 CR 002531, 2025 CR 002532, 2025 CR 0023, 2025 CR 002534, State versus Eddie Law Outlaw. Can I have parties announced?
Jason Garahan for the state, Your Honor.
Martin Guerra, attorney for Eddie Outlaw.
And are you Mr. Outlaw?
Yes.
Counsel, in each cause number, have you received all discovery and did you review it with your client?
Yes, Your Honor.
In each cause number, the court will find that the state is in compliance with discovery. Mr. Outlaw, in each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Lord, I did.
Counsel, in each cause number, do you waive the reading of the indictment?
Yes, Your Honor.
State in the cause number ending in 3-1, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving the enhancement paragraph.
No objections.
And in count ending in 3-2, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving that enhancement paragraph also.
No objections.
And in count ending in 3-4, are you proceeding on the indictment as presented?
Waiving the enhancement paragraph.
No objections.
In each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
In each cause number, you're charged with aggravated robbery. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state calls, and the right to remain silent. Did you understand by entering these pleas you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in each one of these cause numbers?
Yes, ma'am.
Counsel, in each cause number, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Outlaw, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
In each cause number, punishment is to be assessed at 16 years in the prison. There's a $2,000 fine, affirmative finding of deadly weapon. The cause numbers were run concurrently with each other, and the state will take in consideration 2025 CC 006439. Did you understand that to be the plea in each cause number?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
In each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Then in cause number 2025 CR 002531, how do you plead? Guilty, not guilty, or no contest?
No contest.
And cause number 2025 CR 002532, how do you plead?
No contest.
And cause number 2025 CR 002534, how do you plead?
No contest.
State any evidence to support the defendant's plea?
Yes, Your Honor. In each of the cases, state exhibit number 1 with all of its attachments.
No objections.
In each cause number, did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would calling the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
In each cause number, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, in each cause number, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty in each cause number. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, he accepts responsibility for his actions. These were terrible mistakes. For many years now, he has been dealing with a drug addiction, and I think it's safe to say, had he not had that addiction, these offenses would not have taken place. Because of that, we are asking if you could put in the judgment that he be placed in a therapeutic community.
All right, the court is going to sentence you to 16 years in the prison. There's a $2,000 fine. Time and money will run concurrent. There's an affirmative finding of deadly weapon. And this is in cause number 2025 CR 0025531. This will run concurrent with 2025 CR 0025532, 2025 CR 2534, taking consideration number 2025 CC 006439, and the court will request the therapeutic community. And cause number 2025 CR 002532. Court is finding you guilty. The court is sentencing you to 16 years in the prison. Give you credit for any time served. There's a $2,000 fine. Time and money to run concurrently. There's an affirmative finding of deadly weapon. This will run concurrent with 2025 CR 002534, 2025 CR 002531, taking consideration 2025 CC 006439. Court will request the therapeutic community. And cause number 2025 CR 002534. Court is finding you guilty. The court will sentence you to 16 years in the prison. Give you credit for any time served. There's a $2,000 fine. Time and money to run concurrently. There's an affirmative finding of deadly weapon. This will run concurrent with 2025 CR 002532. 2025 CR 002531, take in consideration 2025 CC 006439, and request the therapeutic community. Is there anything else with regards to sentencing?
No, you.
All right, in each cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it, and did you sign it?
Yes, ma'am.
All right, and each of these cause numbers, because these are plea bargain agreements, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. Oh, I'm so sorry. And in 2025 CR 002534, again, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
And because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes.
All right, so here's the thing. You're going to have to start making better decisions. Otherwise, you're going to spend the rest of your life in prison. Do you understand?
Yes, sir.
And if you have a drug or alcohol problem, there are plenty of places that are free in San Antonio that will help you. When you're released from the prison, if you cannot find a place that will help you, if I'm still here, you can come back here and I will find a place for you. Do you understand?
Yes. Opiates.
Opiates?
Yes, sir.
Well, they have locations that handle opiates and alcohol as well, okay?
Yes.
So you're going to have to get control of that. Otherwise, you're going to spend a lot of time at the prison. You understand? All right. Good luck to you, okay?
Thank you, Judge. Here's the dismissal.
Okay. Okay. So here's the thing.
Let me just,
Some misdemeanor courts don't want us to sign these, so they have to sign them. Okay.
well, I can run it over.
All right. Thank you. All right. Do we have anyone else on the docket?
That's it, Judge.
All right. Yes. All right. We'll be back tomorrow for bench trial.